Hey guys, this is Vijay Dinakar. Today I want to talk about what to do if you've been arrested for domestic violence. So first of all, what you shouldn't do is you should not become discouraged and you should not give up hope. It is definitely possible to convince the district attorney to not even file any charges. It is definitely possible that if the district attorney does file charges, that those charges can be dismissed. And it's possible that your arrest could be sealed at a later date. Now, if you hear the ominous words, turn around and put your hands behind your back, and an officer is telling you basically you're going to be arrested, at that point, what do you actually do? Well, what you should definitely not do is say anything at all. You should ask for an attorney and you should entirely remain silent. Now, optimally, before you even reach the point of actually getting arrested and handcuffed, you should have, when you first encountered the officer, when he came to the scene, made absolutely no statement. So again, that would consist of you just saying, I want an attorney, and remaining silent. Now, by law in California, you do have to provide the officer with an identification card, but other than that, you literally should say nothing no matter what the officer says to you. So he or she is going to try to induce you into making some kind of statement. So he might go to the scene immediately and say to you, sir or ma'am, what's going on? Did you hit your wife or husband? Why are you arguing? Those are all traps. You need to absolutely say nothing other than, I want an attorney. I'm not going to make any kind of statement. Remain respectful. Follow all of the orders of the officer, no matter what they are. Don't ask any questions about why you're doing what you're doing. Simply provide the identification and say, I'm not going to speak. I want an attorney. Now, why would that be the optimal strategy, never to talk to the police no matter what, including at a domestic violence arrest scene? Because when you speak, you are, first of all, foreclosing defenses. So what does that mean? That means that if the officer asks you, did you just get in an argument with your wife or husband, or is everything going well, or is there a reason that we were called to the scene? You know, why did your neighbors call? Why did your wife call? Why did you call? That's a trap. If you answer that any way you answer that, that is foreclosing, meaning preventing you from later making any kind of claim about what actually happened. If you say, yes, I was arguing with my wife or husband, okay, well, you're basically confirming half of the story potentially of your wife or husband. So if your wife or husband said, we got in an argument, a verbal argument, and then at some point he or she hit me, well, if you're confirming there was a verbal argument or your neighbor heard a verbal argument, you're now confirming half the story. Again, you're foreclosing defenses. Okay? The second reason is that when you're interacting with an officer, you're interacting with someone trained to elicit both true confessions and false confessions. And I've seen both of those. So the officer's goal is to get you to confess, to make statements that are against your interest, including when you're going to be ending up lying about the fact that you did something. So after the officer continuously pressures you, eventually you might say something that he or she wants you to say. The officer is also trained, and it is a absolutely accepted tactic to lie to you. So he might say, sir or ma'am, your husband or wife already told us that you strangled him or her. Why did you do that, or what is your defense? Now, you might be like, I didn't strangle anyone, and you might want to be, again, naturally making some sort of defense to the officer, but again, that's a trap. And finally, most importantly, the reason you don't want to talk to the officer is that, as you might have heard, anything you say can and will be used against you in court. But the other part of that rule is only if it's going to hurt you. So if you're actually in a trial, a prosecutor can play for the jury your entire statement if the prosecutor thinks that that's going to help him or her prove the case against you. So when I mean play the statement, I mean either your body cam statement that the officer is recording or the officer just repeating what you said, if that's going to hurt you. But if it's not going to hurt you, if it somehow was a perfect statement somehow, the prosecutor can decide not to allow the jury to hear that. So that admission against your interest is something the prosecutor can introduce you only if it hurts you. So it, by definition, means you can only hurt yourself by making a statement in court. So definitely don't make a statement to the officer. If you already have made a statement and you find out you're going to be arrested, at that point, remain silent. So at that point when you're actually handcuffed, oftentimes in a case of domestic violence, the officer will ask the alleged victim if he or she wants to get an emergency protective order or an EPO. And basically what that allows the protected party is to get protection from a court order for up to 7 days. So the officer calls in to an on-call judge and describes in general why the alleged domestic violence victim is facing some imminent danger requiring protection for 7 days. And if the judge okays that emergency protective order, then you will be served with a copy of that emergency protective order. And the emergency protective order will list a number of things. First of all, it will say that you're restrained, when that restraining order expires, how many yards away from that person you must keep your distance from, the fact that you cannot communicate with that person, if you share any common kids with that person and the children are also named as additional protected parties, you're also not going to be able to have any contact with them. If there's any issue of returning of a firearm, that will also be listed on that form. So make sure you keep that form in a safe place, review it, and don't violate it. If you violate an emergency protective order and police are called after the fact, so let's say you get out of jail in a couple days after the arrest and you have this emergency protective order against you, and you send a text to the protected party, either your husband or wife or boyfriend or girlfriend, you've just committed a crime. And that crime, unlike a domestic violence offense, is very easy to prove. All that has to be proved is that you were served a copy of that emergency protective order and that you violated it by attempting to communicate with the other person. So understand what the EPO says, do not violate it, and make sure you keep that in a safe place. When you actually go to the jail, you'll obviously be fingerprinted, your mugshot will be taken, your information will be put into the system. You'll then be taken into a holding cell of some kind, and you'll be able to make a phone call. So, and at some point in the period of your custody, a bail amount will be set. So what you're trying to do at that point is just get out on bail. The bail amount could be anywhere for normal domestic violence offense from $10,000 to $50,000. What that really means is that if you're going to use a bail agent, the bail agent by law can charge you no more than 10% of the total bail amount. So that's a non-refundable fee. So let's say the bail amount is $10,000. Your fee to the bail agent would be at most $1,000. A lot of bail agents will charge as little as 7 or 8%. But basically, they will be able to get you out of custody as soon as possible. So either you can call directly when you have the chance to use the phone, which you will have the chance to use the phone. You can call directly a bail agent, or you can call a friend or family member to call a bail agent for you, who then can arrange the bail. But definitely do not call anyone related to the alleged victim, even if you're not sure if the alleged victim is, quote, on your side or not at that point. Because remember, or you should know, everything you say on your phone call in the jail is absolutely recorded. So first of all, you cannot call the alleged victim, especially if there's an EPO issued. But be very careful about what you say on the phone. What you're trying to do when you're in jail is try to get bailed out. That is obviously the most optimal thing to do as soon as possible. If you can't afford bail, you're going to be in court within 2 or 3 days, excluding holidays and weekends. And what that means is that the district attorney really only has a couple days to decide if they're going to file a case against you. If within those couple days, either they don't get around to reviewing the case or they review the case and decide not to file the case, you're going to be released. So once you are released, then what you're trying to do is, in a normal case like this in domestic violence, you're going to absolutely fight the case. And what you need to do for that is to get an attorney. Now, as far as hire an attorney, you want to hire someone that you trust, that you think is competent, that can handle your case. But again, remember, if you're arrested, do not lose hope. Do not give up. I've seen many of these cases not filed. Many of these cases are ultimately the arrests are sealed. If you guys have any other questions, let me know. Take care and all the best.